Now we can begin to discuss how Asians press their claims towards naturalization rights and challenge the various existing laws that aim to exclude them from national belonging. And the first case actually goes back all the way to 1878. And notice this is just a few years before the 1882 Chinese Exclusion Act. And this is the case of In Re Yup. And In Re, by the way, refers to the fact that this case does not involve two parties. It's just one party. And they used the Latin term In Re for those cases. In any case, this Chinese individual, Yup, well, he began to claim that he was eligible for citizenship due to being quote-unquote white. And here he was referring to his actual skin color. Okay, you can imagine him, maybe he was pale and lighter skinned. So therefore, he's basing his claim on what we call common knowledge or even common sense. And this is based on the sort of phenotype, right? You are literally interpreting phenotype. You could call this a form of phenotypic literalism. Now, he based his argument on that, and a federal court determined that Yup was not eligible for citizenship or naturalization, that is, because he was of the quote-unquote Mongolian race. He was not white. So this actually reminds us of the science of race. And here in this slide, this is what today is called scientific racism. Back then it was just, a scientific enterprise. But scientific racism was the use of science to justify racial segregation and exclusion. And what they would appeal to are the theories of the various scientists or anthropologists that endeavored in this particular enterprise, such as Georges Cuvier. And he put forth the theory that there were three classes of racial groups: Caucasians, Mongolians, and Ethiopians. Another person who basically just added two more groups to Cuvier's, that's Johann Blumenbach. He said, there are Caucasians, Mongolians, and Ethiopians. But he also added the Native American, which he called American, and Malay, which refers to Southeast Asians and around the Pacific Island area. So it's important to take notice of this because in a few moments, we're going to discuss how the Supreme Court is going to appeal to these theories. But with the Yup case, it's actually a federal court. It's a California court. So that's a lower court. But nonetheless, Yup, he basically lost his case because the court appealed to science by claiming that despite your white skin, you are still Mongolian. But interestingly enough, they added a bit of quote-unquote common knowledge or common sense when they claimed that, the Chinese are simply unfit to practice democracy. Therefore, they couldn't be part of this democratic republic. So notice that, by the way, was just common sense. It was not scientific, right? So they're adding, in the Yup case, common knowledge with scientific theory. Now, going back to this timeline, the next court case is 1898, and this is the Wong Kim-Ark case. And unlike the previous case, this was a Supreme Court case, which means that whatever the Supreme Court renders, that's going to serve as a precedent for all future cases throughout the country. Obviously, a Supreme Court renders a federal decision that's effective at the national level. Okay, so Wong Kim-Ark was actually a second-generation Chinese American. That is, he was born in the United States. And, this is a unique situation that arises with Asian immigrants. What about the children of Asian Americans? What is their legal status in terms of citizenship? Well, we already know that the 1882 Chinese Exclusion Act rendered even U.S.-born Asian Americans as, quote, aliens ineligible for citizenship. They're being denied birthright citizenship as guaranteed with the 14th Amendment, right? Well, here comes Wong Kim Mark, and he challenges that on the basis that, Chinese Americans, like any other persons in the United States, should enjoy birthright citizenship. And this travels all the way to the Supreme Court. In the lower courts, interestingly enough, he was denied, but he pressed on doggedly, and finally it migrates to the Supreme Court. And as it would turn out, the Supreme Court would agree with Wong Kim Ark that all U.S.-born children of Asians should indeed have birthright citizenship. So this is a landmark case that even scholars today add on to the 14th Amendment as being a crucial case when it comes to naturalization and citizenship. So that means that, again, all those born, like the Nisei, who we discussed in the case of the Japanese, after 1898, they are indeed citizens. But it's important to note this, and please take note of it. The Wong Kim Ark case does not extend citizenship to the first generation. That is, the immigrant class that comes to the United States. It's only their children born in the U.S. that can enjoy birthright citizenship. Now, during this time, by the way, this is the period of what we called new immigration. As we also mentioned, there are 12 million immigrants coming in within a span of a few decades. So this is the highest rate of immigration we've had in U.S. history, and still that's true today. So you have to remember that in the background, amid all this discussion of Asian American court cases, there's other racial groups that are trying to do the same thing, to press their claim towards naturalization, because it isn't clear yet if they are white or non-white. And let's also remember that the 1790 Naturalization Act, which required for persons to be naturalized to be white, is still in effect, even during this new immigration period. However, it is now under scrutiny in view of all these groups coming in where, hey, are these persons white? Are they non-white? This is what the courts are trying to find out as individuals began to press their claim for citizenship through the courts. And often in these court cases, the reasons put forth by the legalists, that is to say the jurists and justices in the courts, well, they put forth reasons to exclude them, not only based on skin color or scientific evidence or scientific proof, but also reasons such as cultural backwardness, biological unfitness, and there's some social Darwinism, if you're familiar with that, and just basic racial inferiority and claims of intellectual incapacity. So this was a form of judicial racism that was perpetrated in the name of the Constitution, and it does reflect a profoundly racist society during this time of the new immigration period. Now, when we look at the history of the legal definition of white, often contradictory results and rationales are given in the lower courts. For example, let's imagine a person of Syrian descent who arrives in the United States, and after a few years, he or she wishes to be naturalized. Well, some lower courts will say, yeah, this person is indeed white. But then another court dealing with another Syrian individual will say, no, this person is not white. They are non-white. And therefore, they should not be extended naturalization rights. So you can see how in the lower courts, there's no precedent being established. And that's why some individuals, such as Ayup and Wong Kim Ark, as we discussed, will pursue their cases persistently, hoping that it will migrate to the higher courts and perhaps even the Supreme Court. And after that, that establishes the national precedent. Now, it's important to remember that at some points, the courts are going to appeal to scientific theory, scientific evidence. And let's recall the theories put forth by Cuvier, the three classifications, not to mention Blumenbach's categorization of race based on 5 classes. But think about Caucasian, for example. How do you define that? For example, think about that individual from, let's say, Syria. Okay, well, are they Caucasian? Probably not Ethiopian. Well, are they Mongolian? Malay? Well, even the term Caucasian, it had to be argued and even contested. And it's interesting to note that some in the world of science back then defined quote unquote Caucasian areas of the world as strictly Northern Europe and Anglo-Saxon. But then there were some scientists and anthropologists who contested that and argued that there's such a thing as white Caucasian, but there's also such a thing as dark Caucasians from North Africa, from Iran, from India, from Polynesia. So the question is, who is right here? This is highly contested definition of Caucasian. And who or what theory should the Supreme Court, or lower courts for that matter, appeal to in trying to determine who is white and non-white? And still another way they try to determine whether a person was Caucasian or not, or white or non-white, was through language affinities or connection. They looked at the history of languages, let's say, that are common in the Germanic-speaking world, or even English, and if they could trace some commonality with those languages with other parts of the world, well, they concluded that there is some connection racially. So language was a big source of scientific validity or supposed validity. And by the way, this is where you get the term Aryan from, because supposedly Caucasians originated from the Aryan race that was found as south in the world as northern India. Okay, so again, which scientific theory do you invoke as a jurist? Which one do you appeal to?